All right, let's let this meeting come to order. Good evening. May I have a motion and a second to approve tonight's agenda?
So moved.
Second.
All in favor?
Aye.
May I please have a motion and a second to approve the minutes from the last full design review board?
So moved.
Second.
All in favor?
Aye.
Are there any member comments that are not related to an agenda item? All right, hearing none. Let's move on to the agenda. Number one is 1625 Wheelie Avenue. Please come forward, state your name and address and who you represent. Good evening.
Good evening. My name is Katura Collins. I represent the Unitarian Universalist Church in Reston and Children's House Montessori School. I'm here to present for the third time a sign design for out on the street at 1625 Wheelie Avenue. This new sign is of different construction and of different lighting. It is a sand-blasted wood sign as opposed to the metal sign that we had before. And it has exterior lighting. I think if you look on the second page, it shows you what the lighting specifications are. And so I'm just here to present it and hope that we can get it passed today.
Any initial questions?
Everybody has seen the design itself several times, so there's no change on the lettering or the coloring or any of those things.
I just had one question and or comment after the November 24th meeting. I guess that's the date of the letter. We asked them to come back with a more understated sign design that removes the websites. And then again, on the April meeting, we asked them to come up with a less commercial appearance. So my only comment is that the sign that's coming back tonight has the websites on it again. And I thought we'd gotten rid of those 3 months ago, so that's my only comment.
All right. Any questions before we sort of go around the room?
I have a comment about that. I have pictures of several other churches in the Reston area that have their websites on their sign. So I'd like to present that to you as a reason for us to be able to do the same. And as I recall, the last meeting that we had in April, one of the gentlemen here, and I can't remember which one it was, but somebody told us that if we would come back with some externally lit sign, that they would be able to pass the design as it was. So I'm hoping that you will consider that that statement that was said previously, and the fact that there are other churches that have websites on their own signs.
Thank you. Did you have photos you'd like to pass
I
around?
do. I have United Christian Parish and the Martin Luther King Jr. Christian Church. I have two sets of those, so I can pass those around that way.
Well, like
Those
we
are,
talked
yeah,
about
two
these
different signs, but all the same.
somewhere.
Maybe then in pictures, but it's brought up with the right examples. Community.
All right. Do you mind starting us off and providing any comments you might have?
I guess I would echo Richard's comment. I thought we had asked for a little less on the sign. Also, I see the lighting example, but where is that going to be on the big sign?
It stretches across the front of the sign and the other side of the sign because it's a double-sided sign. So it extends out on the top and goes across the front and then across the front on the other side.
Okay, I guess I didn't understand that. Yeah.
Here, this is our copy, so
Same.
same stuff. Pass those over there.
I think the applicant's done a good job with
Comment.
Never mind. We're doing this sign to make it less commercial. I'm okay with the websites. I think they're understated enough. I would maybe ask if the websites stay, that the Reston.org on the right side be made slightly smaller to match the same size as the CHM Reston on the left side, but I would approve this with the websites on it.
That's certainly doable.
Neal?
I don't see a website on the United Christian Parish sign.
It's in the marquee.
On the other side, the
Very-
changeable
Then-
copy.
In the marquee.
It's in the,
It's not on the
it's in the
sign.
plastic letters.
Yeah.
Anyway, I mean, I guess we've talked before about how Wheelie Avenue's sort of a thoroughfare. I question the value of it. I really don't think you're going to be slowing down, but in any case, we've disapproved it on many signs. I'm surprised that there are any churches that do have it. I know we disapproved it on the Oak Brook Church sign up off of Reston Parkway. And we have on the apartment signs typically, just trying to keep the visual clutter in signage here in Reston somewhat distinctive. But I, like the other people, I think it looks good. I really appreciate that it feels like a sign now that fits more into Reston. I like the design overall. I think it looks much less commercial. And I just agree that we take the website text off would be my only request.
Yeah, I mean, I guess I kind of feel the same way, just in both your visits here. That was something that, you know, we talked about each time, partly because people are going, you know, by that sign so quickly. I don't know that it's going to add much value to have it there. I suppose this sign is approved, Barbara? We don't really know that right offhand.
I have not had the opportunity to check. that
Right,
yet,
right.
so I'm not
I do remember approving the much simpler UCP sign. So I do appreciate that you guys have, you know, you've made it much less commercial, which we asked you to do, and you've used elements of the a wood sign now and elements of to tie it into the building. So I think the rest of it is fine, and I would definitely approve it with removal of the websites.
So if I could just interject, this is Bob Howard. He's come with an additional picture of another sign of a church in Reston, Washington Plaza Baptist Church, and they have their website on the bottom of their sign as well. I'm sorry, it's just such a small little picture, but so that's 3 churches in the Reston area that have their websites on their signs.
Is that similar to the United Christian Parish in that it's removable letters? It's not part of the permanent signage?
Because it is
I really
like
can't-
changeable.
It's on the side of the building in the plaza. So
Right.
No,
it's
but
a-
I'm saying, is it a permanent part of the sign, or is it the part that's interchangeable?
I don't think it's interchangeable.
I don't have a,
Where the text can be removed and the.
Right, it looks like it's actually separate. They have other text up here, the winds of grace are always blowing, and that looks like it's changeable, but the part at the very bottom where the website is does not look. I mean, it looks like it's a separate piece there.
It's certainly a very different application in Washington Plaza. It's not a traffic location, it's a pedestrian location. So I don't see that as a directly relevant sign personally.
Although we've even had them remove those from signs in the pedestrian locations too recently.
Exactly.
Well, I think it's come a long way. I think it's a challenging sign because of the 2 sets of messages, but I think we finally arrived at something that's suitable for that area. So, but I tend to agree with the rest, most of the board so far, that the websites is just something we're pretty consistently trying to avoid. I would not be in favor of it in this case. Excuse me, but otherwise I'm okay with it.
Richard, anything else?
I guess it's the same comment. I do think the sign is way, way better. And I applaud you guys for doing that. This is a sign that I think will fit in there. And I think what we're trying to do is to eliminate really busy signs. And I think that's why we made the comments a couple months ago, and I still feel the same way. I think it's a great sign. I can approve it without the website and addresses.
Grace?
I'll concur with my colleagues. I applaud the changes you've made to the design. And I'll agree with Nick. If you could decrease the size of the website for the church. And I have a question. Are you going to have some vegetation around there? I know existing, there's just
Yeah, it's
grass.
pictured here. We have quite a challenge with vegetation because right where this sign sits is a big culvert, a big ditch, and a large piece concrete piece that goes across there, so we'll do our best in order, to put something up, but it is going to be a challenge for us.
But with the materials you've used, it softens the appearance a little bit, because for other signs, sometimes they do have some landscaping in the background to sort of
We
soften
hope
the
to
appearance.
we hope to put something there, just not quite sure what it's going to look like because of the challenges of the actual space.
Thank you.
Ken?
I concur with colleagues here. I think they've come a long way. And I'm 50/50 on the website addresses. I'm not a big fan of it, but so that's the only comment I would add.
I have a question for the board. If it was a phone number in lieu of a website, is that different in your all's eyes?
No.
Okay.
So I agree, and we have tried to not have websites on signage in general pretty consistently in the last few years at least. So I agree with not having that on there. So are there any sort of comments to you?
I just said I think it's very disappointing that I've been able to produce for you 3 different churches that have websites on their signs, and you're telling, many of you are saying that that's not acceptable. I don't understand that.
Because you can find about 5 or 6 or 7 or 8 that don't, that we have reviewed. I'm not sure that we've reviewed these particular instances.
How can they be signs in Reston that you didn't review? How does that happen?
People do things all the time without asking permission.
They may be a violation.
Oh, I see. That never occurred to me.
You brought it
That
to,
somebody would put up a sign when they weren't supposed to, or that they would do something that they didn't ask you for permission. And that never occurred to me.
Unfortunately, it happens.
Okay.
you're absolutely not being singled out in any way. This is our attempt to be consistent. If we allowed it here, we would have many more instances where people were concerned that it had been disapproved for them. I don't remember ever approving it myself.
Yeah, I don't know.
Great.
Any last comments? Anybody willing to make a motion?
I'll make a motion that we approve the latest submission design of the sign with the stipulation that the websites do not appear on the sign.
I'll second that.
Okay, we have a second. Any other comments?
It does seem to me that the Children's House Montessori School might want to recenter slightly in that panel once the website is removed. So I would offer that as a
That would be fine.
part of the approval.
Move it down a little bit.
Any other comments? All in favor?
Aye.
Opposed?
Aye. Just thought I'd try.
With stipulations. So.
All right, so can we just submit a new picture and be done with it, or do we have to actually come back to you again?
I don't think you need to come back.
You're done.
Yeah, I think you can work
It's
with
approved,
staff.
just, yeah.
We will redo the picture and we'll send it to our staff person, Trevor, somebody?
Yes.
And
Perfect.
assume that it's done.
Yes, thank
He
you.
will confirm for you.
He will confirm that it is done.
Yes.
Okay.
Yeah, and they'll send you a letter within the next week. So, thank you
All
very
right.
much.
Thank you.
Being here this evening.
Good job.
All right. Next on the agenda, the Exxon sign 11854 Sunrise Valley Drive. If you're in the audience.
Nobody's here for this one.
Yeah,
This
this
is the
is-
one that I had emailed to you all. You
Oh, the
needed to
right,
go
yeah.
and visit. Can you hear me, Sean, or do I need to move the mic?
I can hear you.
Okay, all right.
So no one's going to be
Speak up.
attending. Okay.
So this is the one where it's the Exxon sign at the Sunrise Valley Station. We received a complaint that the sign above the door was too bright.
So the A+ sign,
The A+ sign.
the semicircular A+ sign.
Yes, and you all were asked to go and take a look so that you could render an opinion as to whether that sign is too bright and warrants them coming back before you.
And there were other items in that letter, other complaints about other stipulations that they felt had existed in the previous application when it was first built. Are we not
None
discussing
of that was part of the previous decision, none of it was stipulated as written. The only piece of that complaint for you to look at is the sign above the door.
Okay. Because when I went out there, it seemed to me that there were light fixtures that were not part of the original approval. So if
I
we're
wondered that as well.
restricting our comments to just that portion of the sign, then I guess we can do that. But
Yes.
I think part of the problem may be that there's other stuff happening out there that we did not
If there's other
explicitly
unapproved,
approve.
if there's other unapproved installations, they'd be design violations, which we would approach through our normal process for that. In this case, you all rendered a decision on the sign, and there was wording added to the sign that said, if, in the DRB's opinion, the sign is too bright, then you could require that the illumination be lowered. And that's why this is back in this fashion, is for you to determine if, in your opinion, that sign is too bright. The other items, if there's anything out there that's been installed without approval, we will be going after it as a design violation. That is in process as well.
Okay.
I mean, I don't know if, it seemed very bright to me when I looked at it tonight. There was all the other lights that she refers to in her complaints, the fluorescent ones, which I guess weren't on in years past, and I don't know whether or not they were part of the lighting package that we approved most recently with this building, but I would say that the A1 plus sign is too bright.
Yeah, I would agree with that. I think the A1 sign is too bright, but along with all these other lights, it's really too bright. But
Yes.
what we're saying is that has to be cited as a violation before we can really say anything. So if we got to start chinking away at this, I would say the A plus sign is too bright, and hopefully we can go from there and dim the whole thing down a bit.
Yes, Ken, do you want to work on it?
I drove by, it is too bright in my opinion as well, so.
I concur.
I do too.
I just want to observe, like Richard did, that this one's been around for a long time in a couple of iterations, and it's always been somewhat unique because of the residences that are all the way across the golf course that look directly at this station, and so I think it's more sensitive than a lot of signage that we look at, and so I concur, of course. If the residents over there, any of them are complaining, I would say that we should ask them to make it dimmer.
I would agree. I mean, it looked like the other A-plus signs I've seen, but because of location. I think, the others I'm used to are strictly commercial.
Okay. Do we have a motion?
I would move that we direct the applicant to dim the lights due to excessive brightness and complaint from the residences across the golf course.
I'll second that.
Any other comments?
Do we have any obligation to specify something quantifiable, or we're just saying?
50%.
I don't
very
know how it's
subjective.
controlled and, yeah, okay.
Noticeably dimmer.
It really.
I felt 50% dimmer would be better for that, given all the exterior lighting on the building.
Approximately 50% dimmer in our estimation. That sounds reasonable.
Do we want to hold judgment until we see what the other light issues may be?
I mean, to me, it's until you get it kind of right. Might still be too bright.
And I mean, the brief history of this, when this gas station first got done, the gas station backed up to Sunrise Valley. And there was huge conversation and discussion about the fact that they were flipping it so that the front of the station looks at the street. And we probably had 40 people at some previous DRB meetings not liking the fact that it did that. Because like the Sunoco and South Lakes backs to the street, that one did too. So this is a very sensitive issue, is why you're hearing about it now. That, 15 years ago, 10, 12 years ago when we did this, that was one of the things. They didn't want these bright lights. So I fully understand his complaint. Hope there's something else we can do for the rest of the brightness that's there.
Okay. We have a motion and a second. Any other comments? All in favor?
Aye.
All opposed? Motion passes. I'd like to make a motion that we adjourn into executive session.
Second?
All in favor?
Aye.
Opposed? Very good. So let's move into executive session. Thank you. Ms. Fulkerson, please proceed with your report.
Thank you, John. Julie Bitzer, the board liaison for the DRB, is with me. She and I had the opportunity last week to go over the edits that were made to the two resolutions that are before you for the Design Review Board, Covenants Administration resolutions. That's Resolution 7 and Resolution 11. And the first one had to do with Design Review Board meeting requirements. The BOC, Board Operations Committee, took a look at the proposed edits. One of the discussions that came about was really in relation to panels and who can substitute. So there was a fairly lengthy discussion at that time. They had no problem with making sure that you guys had the ability to substitute, but one of the things that came up, and Julie can elaborate on this, is making sure that we are true to the deed language that says that panels are made up of 2 design professionals, 1 lay member, and then if you're seeking a substitute, that we need to do like for like. So that was the proposed change that was put in here, just to clarify this, and we welcome edits from council, but it says the amendment here was design professionals can substitute for each other when a vacancy exists on any panel. Alternately, lay members may do the same. So that was the clarification that the Board Operations Committee made.
We understood that to be your intent, but we wanted to make sure it was clarified in the documents.
We're just discussing this, right? I mean, that's what we're doing?
Yeah, so are you looking for any kind of vote on this?
It's slated to go and be adopted by the board as a consent calendar item on October the 27th, which is next week. The board packets haven't gone out yet, but we wanted to make sure that you had the opportunity to hear what those edits were before it went into the packet.
So weigh in, and as it stands, like Cate said, it would be considered a consent item, so it wouldn't come up for discussion as part of the board meeting. It would just be, here's what it is. Anybody, we're good with it, right? So it's important for us to get your input before that.
I guess first question I have is for council. Do you have any questions, comments, concerns with any of the language? Have you had a chance to even look at it yet?
Yes, no, I had a chance to look at it.
Okay.
We talked about it this afternoon.
Okay, good.
The new changes. And it achieves the goal of maintaining the integrity while allowing you guys to have legitimate panel substitution, which is what we really wanted to achieve, without having to have another meeting to do the substitution. So it gets you home.
Thank you, Will. Any comments?
I just have one comment that is the same one I've been making all along, that, you know, the system we had for 20 years that I've been on this board worked just fine. And it always bothers me to compensate whatever for certain things, and it still could leave us with 2-member panels, which is my primary objection. If we did have an instance where a layperson couldn't come, we couldn't get a layperson substitute, and we end up with a 2-member panel. That's the only thing I've said consistently. That's what I think we're trying to avoid, because I think 3 always, it just works better than 2. And this still handcuffs us to the possibility of having 2-member panels. And if this is the best we can do, then I understand all the legal schmeagle stuff that we're talking about and why you're doing this and so on, but I think it's kind of sad that this has to happen, quite honestly.
And just for clarification's sake, not, just so to Richard's point, and I think council was going to say this, so I'm going to pretend that I slept at a Holiday Inn Express and say this. So the rule for quorum requirements for meetings for the association is 51% of a group. So even though you might have a 2-member panel, that is considered meeting quorum requirements. So if for some reason you couldn't get a substitute and you had 2, you could still hold the panel. That would be the case for this group. If there are 5 of you out of the 9 that are here, you could still hold your DRB meeting, same thing. So just not at all to go against anything that Richard's saying, just so you understood what the rules were. Was that what you were going to say, Council?
Right. I was going to say that is the case. And the only philosophical question is there, from the board's standpoint, any problem with going forward on a quorum basis without the purity of the 2-1 representation?
Our focus had been on the panel meetings?
Okay, we're talking panels, but if the panel has a 2 professional, 1 layperson representation, that's what the deed says it's supposed
That's
to
what it
consist of.
says.
And
And any
if a
substitution of any
layperson-
members of
But what if
that.
they can't, what Richard's speaking of is that if they can't get a substitute that fits the criteria in a given meeting, they go forward because they have a quorum, so that it could be a 1-1 or a 2-0 panel, but because 2 out of 3 is a quorum, they could still go forward. What traditionally happens is they offer the applicant an opportunity to defer until they can have the full panel if they would prefer, but if they, since they're there, they want to go forward, to accommodate those that would just as soon go forward, they let them go forward with 2. I wanted to make sure that the board's view on that panel constitution of a 2-1, my sense is that there might have been some desire for total purity on that and always have that or not go forward. And if that was the case, I wanted the DRB to hear that. And if that's not the case, then they can go forward as 2-4 with a 2 if the applicant doesn't object.
There are situations, Julie, where you could have 2 no layperson at the panel meeting. Do you see that as an issue?
Or 1 and 1.
Or 1 and 1,
Only
and
one
depending on the experience of those 2 members, you might run into issues with decisions, I think just based on experience levels there, so.
The way I read this document as it's stated, and not to say we've addressed the issue of quorum of 2 versus 3 in a panel, the way I read the panel meeting thing is says each panel shall be composed of at least 2 and at least 1 lay. It says nothing about quorums of something less than 3. So when I read this, now if you're asking whether or not there ought to be a situation where a panel could be comprised of 2, I don't see the provision in this document as that's stated. If I've missed something, please advise me, but that is not something we discussed in the board BOC meeting.
And that was something that, this wasn't trying to address that because that was a given, but the way it's structured, and it doesn't spell that out, well, it could be broad to do so, but the way it's structured, the panel is comprised of the 2-1 personnel. Whether or not the 2-1 actually show up, the panel is considered the body. The body is the 3 that are named to that panel. That comprises the panel. The actual participants, which is different from the actual panel, is the people that actually show up. So if 2 of the 3 people on the panel show up, the panel still exists as a panel. The panel still has its assigned members, but they could go forward with business because they have less. Just as the board is comprised of X people, but if less than X show up.
I hear you. So if we feel that as in A1, where it does speak to a quorum, which is not spoken to in A2, that we need to add wording with regard to a quorum for a panel, then I would suggest that we still have work to be done.
That's
I
not
don't
the
think the
issue.
issue that was raised
No,
was
that's-
about quorum. I think the issue is that it's possible, if not likely, that with the way it's written, particularly with the layperson position.
Right.
If a layperson, one of the assigned layperson can't make it,
Right? You
Then
can
relies
substitute
on-
according to A2
there's only,
with a layperson,
I understand, there's only 2 other people that could possibly be.
right?
So
It's
if-
conceivable that may not happen.
If they're not available, then we're restricted to we're automatically restricted to a 2-person panel, which technically is fine, it's a quorum. But I think there's a general consensus that it's better to have 3 people, regardless of the makeup, in a substitution case.
So really what you're asking is, could you substitute a lay with somebody of a different category?
Could a professional stand in?
And that is not what's currently written here.
Yes, that is
That's
kind
what
of
I'm
what we
saying.
would
That's
like.
what we've been talking about for X number of months.
Right, so you do have an issue with what's been presented to you for consideration.
Yes.
Yeah,
Is
we're
the net-net.
consistent in what we've been saying. And the other thing, if you read through the rest of the governing documents, later on in the governing documents, there's a thing that allows our secretary, in certain circumstances, I think it says extreme circumstances, to appoint a substitute for a panel of a previous DRB member that's not even an active DRB member. And that's part of the governing documents. So that's why I think
Bylaws.
wherever it is, it's in that little
In the-
book we
of
all
the package,
wave around.
right. Mhm.
So, I mean, it gets really kind of squirrely. My only interest in this whole thing is, I think we function better, and for all the almost 20 years I've been doing this, I know we function better as the 3-member panel.
Right.
Period. And I was trying to get this written so that we don't get trapped into a two-member panel, which this will do. And we had that, if we can only substitute a lay with a lay,
And I
we
still
had
don't see
that
how
come up,
this
what, 3 or 4 months ago? And
puts you into a two-man.
The red one that's crossed out would have done it.
Yeah,
the one that's crossed out would have done it.
Matter of
Exactly.
practice.
That was not the intent.
Those two
I
don't
think
say.
the intent from the board was to to preserve a three-member panel.
But how
So
does
the key
that,
is-
yeah.
pardon me for saying, but if we stick to that and achieve your goal, that means as a practical matter that if they don't have a layperson available, anybody, then the panel can't meet.
Right.
And is that your desire, that it's all three or zero or nothing?
No, the panel can still meet because you still have a quorum, but we're
Yeah,
trying to
not if
avoid
we
that.
achieve the goal that the board has in mind. The board
Which
wants
is your goal? Is your
purity
goal
of
a
panel composition.
three-member
Always.
panel?
Well,
And that goes right to what's in
So-
the deed, so we're flying against the face of the deed if you allow something that's not the 3 or the 2 and the 1. That's the issue. And it has, just so we're aware, usually there's a rule for a reason. It has come up, as Anna and I have had, there've been some cases where residents have noticed that. So
Sorry, noticed what?
the panel makeup was not as stated in the deed.
It's interesting, just as we had with Nick, where he's a design professional who used to serve as a layperson and now serves as a professional.
Right.
So, you know, it really is a distinction often without a whole lot of actual distinction. It's just how you were appointed at the time.
Yes.
It could be a design professional who's serving as a layperson when he's appointed or she's appointed.
But it's the position that you hold at the time.
You know, the knowledge of any person on the board or the personality or the decision-making philosophy of a member, from my perspective, isn't really based on whether they're a design professional.
You're really
It's the
violating the premise
individual.
of what a board is all about at that point, though, Neal.
Yeah.
I mean, where you're getting into judgmental decisions as to whether a person's professional affiliation, whatever, qualifies them over another board member. That really gets iffy. I'd be careful going into that.
And I wasn't suggesting that. I'm saying that we all have certain ways that we approach every application regardless. Nick didn't become different once he was appointed as a
I
professional.
understand, but you have to, we are a corporation. We have to follow the bylaws.
I don't think I have
So
an argument
as his
with
present position states, he is now in his present position. I'd love to be able to do that, but then we could get flaky on a lot of other things.
so over the last 20 years, as you said, Richard, we've had many instances where we had a two-person panel because someone got sick, someone got stuck in traffic, whatever. There's a lot of reasons that can happen, and it has happened. But we've used that as an option based on, our understanding was the bylaws we were following for a quorum. Is that not the case?
The bylaws do state that the quorum for the DRB panel is
Say
2
that again.
members.
I can't hear you.
Can't hear you.
We can't hear you down there.
I'm sorry, the bylaws do give the quorum requirement for the panel, so it is the majority. So it's not just for the full DRB, it is also stated for the panel.
I think you're going to want a little flexibility here, right? I mean, to be able to adjust to things that you weren't expecting, right? If we all show up for a meeting and someone can't come, everyone just has to go home. I mean, that doesn't make sense, right?
We've done that on the buck.
When we haven't had quorum,
Right.
it's the quorum piece that's key. So, and you could have I don't know if it's completely, you could probably have a DRB meeting with all design professionals and no
Yes,
lay
exactly.
members.
Right.
So, no different
Would work.
on this.
Right.
It is what it is. So it's just, the language that was added during the BOC meeting was to preserve the
Makeup.
the makeup
the
that
2 to
was
1.
stated in the deed.
Right.
Well, I wonder if you need to just add a clarification that says that if for some reason there's only 2 members of the panel, the applicant
Still a
has
quorum.
an opportunity, it's still a quorum, but the applicant has an opportunity during the meeting to request that their agenda
Application be
item be
reconsidered?
postponed until the next meeting.
I thought that.
But we did that anyway. Just,
I don't think that language is in here.
Yeah, that's just a matter of practice. You could add the language to crystallize that.
If you wanted to clarify that so that we had that flexibility, personally, I would
let me try one more time, and then I'll be quiet, okay? In the interest of the design review board, and I say, okay, all this legal stuff, I'm not arguing that, that's what Will's here for. But my main concern after all these years is that we present the best possible thing we can as a design review board. And I think having a full panel every week is very important. And if this handcuffs us so we can't do that, then I think that's a problem. I mean, in the almost 20 years I've done this,
How does it
hold on a minute,
handcuff?
hold on, let me finish. It's probably 1,000 meetings, okay? It's a lot of meetings. In all those meetings, or maybe twice in my recollection, we ended up with a 2-member panel. Somehow we always manage to drag 3 people in here, whether it fits this or the legal this or the legal that, and it's always worked, and we've always looked fine. And if we couldn't get a layperson, we just stuck whoever volunteered in there, and it went fine, and it was smooth, and no one worried about it. We did have an instance where, last year I guess it was, and this is the one that sticks in everybody's craw, I think we had a professional and 2 lay people or whatever. It was the one with the silly railing over on wherever it was. And that is still bothering people to the point where I think that's why we're doing this. And I think, okay, that was a bad one. It didn't work out well. Hopefully, wherever we are with that, I have no idea. But I just concerns me purely from this side of the table that I don't want us to get handcuffed into some kind of non-substitution thing where we can't present our best look and our best deliberation with 3 people is always better than 2. That's what I'm concerned about. And if just the legal schmeagle stuff says we can't do that, then we're screwed.
To me, I think the 3-member panel is important. No offense to the lay people at the moment, but if I was choosing how to do it, and I'm not trying to represent the rest of the board, if I could not replace a lay person with and I needed to replace a lay person with another design professional to maintain the 3, that would probably be the way I would want to approach it. That would seem logical to me.
And that's what they want, but that's what
That's
this
all we're
wording
saying.
prohibits.
But I don't know how
The original wording allowed that.
Right.
The wording limits that.
The red letters did.
Yes, but I don't know, is that is that even an option that we could word it such that should a layperson not be able to substitute for a layperson, the next option would be to ask
You
another.
can certainly word it such that every effort will be made to replace like for like, but in the event that is impossible, then.
With the goal being that we want to have a 3-person panel present at all times.
That gives you the best, leads you to the best first, but if you don't do that, then you go with whatever you can get to keep the 3.
Something to keep in mind when you have full DRB meetings, that if more than one conversation is going on at a time, it is picked up. So I highly recommend that, for your purposes, that one group speak at a time. As Sean, if he's nodding his head behind me, will say that the multiple conversations going on at one time did get picked up. So I am mostly concerned with making sure we abide by the deed. If council feels that we're able to add a clause in here that in extreme circumstances we can allow any member of the design review board to sit in as a substitute, then and feels that in a court of law we're able to do that, then by all means, I don't have a problem with it, because it's going to be me with counsel defending the association in case that this comes up. But if we're able to do that, then and Julie is comfortable from the board's perspective.
Well, I am, but I also want to be cognizant of those people who have performed the role of the layperson. Because we do have a layperson on the design review board for a reason. And they bring a different perspective that I don't wish to see shut out of a panel unless we cannot, go forward and conduct business. I mean, I don't think it's fair to the homeowner to be in a situation where they come to a panel and all of a sudden they find, oh, go home. We don't have a quorum.
I think we all agree with that. I think the issue is that it's most likely, under this language, it's most likely that the layperson would be the one who's missing.
Right.
So they would be missing regardless from that meeting. If we went
Right.
with a 2-person professional meeting,
Preserve the
I feel like it's
6.
still more beneficial to have that 3rd person, even if it's a design professional, because
Right.
the lay perspective is already missing from the whole procedure at that point.
You know, if
anyhow.
you can't find it, but.
So why don't we
have
give
some
everyone a
lay-
chance to?
Yeah.
Well, I think part of the issue we haven't talked about yet, there are only 3 lay members.
Right,
And there are 6 professionals.
that's right, so
Much
easy to
easier
replace
get
the
a
other
substitute
2.
for them than
Mhm.
us.
Yes,
And I think we've worked it out pretty well so far. But, I mean, and that's not going to change, so it's a matter of numbers.
right.
I personally, I've been at a lot of DRB meetings. I don't think most people realize the difference between the professionals and the lay people. And I'm not sure most of them even expect a 3-member panel, to be honest. And I mean, that's from being on the side presenting.
Okay, that's true, you have the cluster
And I appreciate
experience.
everyone's concern to make sure, you know, everybody is represented and a 3-member panel. I agree with Richard there. But, I mean, I came here for years and I had no idea what the makeup was. I can't tell you if I always had a 3-member or a 2-member panel. I mean, I do understand what everyone is saying and I appreciate that, but that's just from my perspective as a presenter.
Nick, any comments?
Agree with Richard.
Neal?
I like adding that line that in the event or in unusual circumstances when a layperson cannot be found, a design professional might substitute. It seems to me that design issues are just so subjective, and that the more opinions that are being represented from 3 people gets the conversation going, it lets the applicant see that it's being discussed thoroughly, and while I understand, I think, in a way, the idea of the layperson being a different representation, my point earlier, and continues to be, that all of these things can be discussed well by anyone, and the 3, to me, is more important than the 2, if a layperson isn't represented at all anyway.
Barbara?
Yeah, I agree. As I think Will said a few minutes ago, if he can craft something that said, you know, substitutes will be selected like for like, wherever possible, that's the first thing to do. But in the extraordinary circumstances when they cannot, a non-like panel member would be allowed. If we could just have language like that, indicating that it's kind of extraordinary and there's this hierarchy of decisions, of selections for the substitutes. I think we can keep the integrity of the panels that way.
Yes.
Just, I forgot to say also that I just think we've seen in the past that it can wear a substitute out.
Oh, yeah.
If we have a member who has an extended issue, a lay member with an extended issue, those 2 people are going to get worn out, and they feel like they have to be there because we want that 3rd person.
Right.
And we've had that happen in the past with, frankly, with design professionals. It happens too. So it just gives more flexibility.
Just one point of clarification. Are you saying that we can exchange any of them, or is it merely a design professional for a layperson if a layperson can attend?
Okay, I'm different than him.
That was my understanding.
Okay.
of
So
what
it
Will
seemed
was
like you
saying.
guys were
Yeah.
saying something different.
I'm saying
Seem to
something
me, any
different.
of the other 6, I think is what you're kind of going towards.
Yeah, in extraordinary circumstances,
Anyone can
a
fill it.
body
Anyone
on
can
the
fill in for
board
the lay.
would be allowed to substitute.
Because if you're looking at, in theory, their training or background, right? Any of you would have more, except for Nick, because he was one of those exceptions, would have more professional and in the landscape, in the design, architect space than perhaps a layperson.
That's
would
true,
have
but I
been-
think it also depends on how many years of service on the DRB you've had, right? And so, in Barbara's
That's true.
case, she's been on the DRB
Right.
for a long time. She probably has better experience than
Probably does.
some of us who haven't been here as long, right? So-
Right.
So you can.
If you're just
Wasn't
looking
it a
on the
design
paper.
professional?
Yeah.
Yeah, I was surprised too when I heard that. Graham, any?
I don't think I have anything more to add. I think we've stated it all. I think if we could get to this sort of language, I think would be great.
Do you have a preference one way or the other?
In terms of
What, between, Neal and Barbara said?
Well, since I think what we're trying to get to is, I think it's most likely that it's the lay position that would not be able to be represented. If we'd had to be restricted to just say the professional can take the position of the lay person, in the case that there's no lay people available, I would be fine with that. As opposed to saying anybody can be anybody.
Yeah, I don't think that was the intent. I think we were just trying to deal with the fact that the layperson, you had 3 people, and your odds of being able to fill that were a greater barrier, a greater burden.
Richard?
I think everybody knows how I feel about it, that's fine.
Grace?
I'll agree, but I would question this. Should we add a clause where we actually inform the applicant that because we don't have a lay member present today, we're substituting with a design review member? So in this case, they do have 3 professional design review board members instead of 2-1.
To give them the same option as if we only had 2 people there?
Yes, I'm just placing the question out there.
That'd be a legal issue?
Sure. There are 2 ways to handle it. We could either state it in the rule that that's the way things will be, or we can just have a waiver form that says their panel was not constituted of 2-1. If you would prefer to have a 2-1 composition, you may defer your application to a later date. If you are okay with going forward with the panel as constituted and state what the Constitution is on that given day, then please sign this waiver acknowledging that you're ready to proceed with this panel, which is what we would report often when people don't get a judge, they get a magistrate.
And I'm sure in most situations, they would go ahead and proceed
yeah,
because
99%.
now they
You're also
have
asking them to take one more step that maybe.
You're giving them knowledge, and so they can make a knowing consideration about what they want to do, and you're giving us some protection by saying you didn't get the deed allowed composition, but you still wanted to go forward, and you decided to do that voluntarily of your own volition. Therefore, we've got, if they come back later and say, I didn't like the decision because I didn't like the composition, they've waived that, and waivers are recognized.
That's a good comment.
But then logistically, Barbara, how much notice can you give somebody who's coming before a panel to say,
That's an on-the-site thing.
It could be on site?
They sign it when
Okay.
they get there.
And we may not
We
know until
effectively
the
do
last
that
minute.
already
Right.
when there's only 2 people. We already give them that option.
Okay.
So I think
So
it's just an
change.
extension of the same courtesy.
We just don't get their signature, which is what you're suggesting.
Right. This way you get a waiver, and that way you have better protections for the association and a clear record that they were given the opportunity to have it at another date if they preferred.
Okay.
I mean, I assume that's the extraordinary circumstance when you find out at the last minute that somebody can't fill, because we don't have now the description of what the extraordinary is.
Right.
So I'm assuming it's when we don't know until the last minute that somebody can come.
Ken, any comments?
No, I think everybody's gone over it pretty well. So I agree with Will when he started this questioning. It was, is there a need to address what appears to be the purity of having a 2 design professional, 1 lay member composition? If that was written by people that put the bylaws together for a reason, I suspect. And so this DRB, future DRBs 20 years from now, is that something that is important to the association? And if it is, then we should write the language accordingly and try to get as close to that as possible. Because I see that we did even extend an extraordinary circumstance. It says if 3 of the lay people, which are the minority in the group, are not available, there may not be a pure panel able to meet. They could meet legally, but it's not the purity of having a design professional and a lay person. Maybe homeowners do want to have a lay person there to give their opinion. I don't know. So my point to all of this is that important to us, and should we write the language accordingly to emphasize that we're doing our best to protect the purity of having design and lay people addressing your need as a homeowner versus just 2 design professionals or 2 lay people or what have you. If that's important, then I think we've got to stress the language accordingly, because ultimately it'll be Will or his counterpart and Cate in a situation where we'll hear about it after the fact, where we're spending a lot of legal dollars to deal with a homeowner's issue. So I want to make sure we avoid ambiguity here. And right in the beginning of the sentence, I see this purity matter. Each panel shall be comprised of at least 2 design professionals and 1 lay member. Why was that put there? And why are the lay people here?
So Julie and I just did a quick consultation, and I'm feeling that this should come off of the October 27th board meeting agenda, and that she and I need to go back and definitely check on the purity question of this. So I think that we've gotten feedback enough now to go back to the November VOC meeting and say, okay, there was a discussion about purity, and how do you feel about that?
Quorum versus purity.
Right. What's more important? Yeah.
If it's just me on the purity thing, don't let me slow it down.
I don't think you're saying anything that's controversial. I think what we're saying is that the purity is established already in the 2 to 1, and then if the 1 can't make it, and nobody else could substitute, that we feel like once you get to that point, that it's better to have 3 than 2.
Should we take the extraordinary issue, should we take the clause that says this is an extraordinary issue, we need to find a layperson? Is that important to us? Instead of finding another design professional to fill out the 3rd spot, should we go the extra mile to find a layperson, a former layperson, former DRB layperson, to be on that position?
I'm sorry, the emergency only is only a former DRB chair.
Oh.
So it's an extreme circumstance. The DRB secretary may have a former DRB chair serve.
Okay.
But maybe I'm confused. I thought what we had talked ourselves into was, in the case that a layperson couldn't be there, the first step would be another layperson. And only in the event that another layperson couldn't be there, would you have the possibility of adding a 3rd professional.
Right.
And
So,
even then,
so the first check is to maintain
Is like for like.
purity, and then beyond
Second
that.
is, if you can't get there.
And was there a clarification that you had on the
On the bylaws, it says a former DRB member may be asked by the DRB secretary or the designate to sit on a current panel in the event of an extraordinary circumstance to establish a quorum. It doesn't have to be a DRB chair.
It doesn't say chair, it just
It's
says
just to
member.
establish a quorum. That would just be up to 5.
Was that for a panel or just the full?
It doesn't specifically
doesn't
say
say.
one or the other.
if the basic issue is, among others, fairness, perceived fairness, to me, having that waiver or that optional statement really gives the applicant that
You know,
right.
you're being reviewed by a panel of 3 design professionals. Is this a problem? You waive out to the next time.
And as Graham says, we would try going down the list of lay people and exhaust that possibility.
Right, and that's the way,
Before we
yeah,
would bring in
so we would just
a
add
3rd
some.
person.
I think
Do
we
you
need,
still want to go back to BOC?
yeah, I
Okay.
still think we should
Okay.
go back and add a little bit more verbiage from Will to make it clear what happens when you can't find a layperson.
It sounds like we
The
just,
integrity is to get to the 3 panel. That's, I think, I'm sensing, maybe I'm wrong, but I'm sensing that 3 is the goal.
it is, but I think we're asking for flexibility, even in the sense that if only 2 people show up, I think we need to have the flexibility to proceed. And so I think the waiver that Grace mentioned is a great idea, that we have someone sign that.
We already
whether-
have that one in place,
But
right?
not the actual waiver.
Not an actual
Not an
waiver that
actual
we sign.
signing. It's a verbal notification.
They have an opt-out orally
But
presented.
to be
But I think
clear,
that-
the waiver would occur in the instance where there's only 2 people, regardless if it's 2 professionals or 1 and 1, or in a 3-person panel where the 3rd person substitute is a professional in place of a layperson.
That's right.
That might alleviate a lot of the issues. It gives the homeowner the total opportunity to say, let's move it to a time when I have the right panel assignment.
Let us go back
Okay,
and
thank
talk with BOC about that, and we will come back to you again next
Well,
month
yeah.
and get council's language for that. Fair?
Fair, thank you.
Great.
And the next one?
Hopefully the second one on Resolution 11 is not quite as complicated. So it's my understanding that DRB Secretary staff has gotten questions, comments from applicants who were looking at new development, redevelopment, and they've got a comp plan amendment, development plan amendment, or whatever, what does it mean? What information do they have to have in advance? Because we have said no to an applicant recently who didn't quite have all of their stuff together. And we had a conversation with you guys last month about, give us the timing. On consultation with our land use council, recommendation was they have to have it all packaged, ready to go by the 21st, by 21 days in advance. No 14, no 7, everything's got to be in, ready to go. It was felt that anything less and giving them more time was not fair to you, not fair to the membership who was looking at an application. And we were informed that they're used to that at other levels when they're presenting information. So that was the advice that was given. What's before you is kind of the language that we came up with. Julie and I brought that to the BOC to take a look at. But recommendation from land use is just make everything ready to go 21 days in advance.
And this applies to information sessions as well as actual reviewing of the application.
Yes.
Meetings, but it's all what's occurring at a DRB meeting or a full board, not how to work sessions. Work sessions are not covered in this, correct?
They're not part of this
Okay,
resolution.
I just want to clarify.
But you understand that work sessions of the board are open to the public?
Yes.
And I see a pause right now.
Me too. I guess I want to know what you mean more by the work session. Because to me, a work session would have had there wouldn't be a reason to have a work session if somebody wasn't already thinking they would be applying. Am I incorrect about that?
No, that's correct. A work session traditionally has been the very preliminary stages when they want to come in and have a conversation with the DRB to get a take on, are they moving in the right direction?
Mm-hmm.
Typically, these are special meetings. They're not part of the full board meetings. They're special work session meetings. They're done at the availability of enough DRB members to make it worthwhile and the applicant. So they're often lunchtime type meetings.
So I'll tell you what, I'm inclined to go back to land use because land use is going to say that smells a lot like a pre-application meeting.
Mm-hmm. Okay.
And
Exactly what
and how do you define the term information session? So
Yes.
I think that
I'm thinking
clarify definition of those. I'm sorry. You're saying you need to clarify definition of information sessions.
Correct.
Work sessions, pre-application meetings.
Well, I mean, a more familiar term outside of this room would be a pre-app meeting.
Okay.
So
we should probably adopt that terminology then, I would think.
So let me work on that.
Just a thought too, that we seem to have three different things, to go back to what Julie's saying. We have had informational only meetings where you didn't used to have to notify people would come in, so on and so forth. Okay, we would then have what's called a workshop, and that's another thing altogether that we're not addressing right this second. And that's where the applicant comes in, like Barbara was saying, and frequently we get lunch.
Right.
And we all sit around and discuss the project kind of
And more
informally.
casual, being able to,
Yeah, right, it's more.
not necessarily off the record, but still something where you're just kind of.
Yeah, exactly. And then you get the application meeting.
Yeah.
So there's three things we're trying to accomplish here, and they're all open public meetings, so there's no problem with that, but they all accomplish a different thing, I guess.
And how, if somebody wanted to come to a work session, casual, whatever, how would they even know that?
Aren't work sessions posted on the website as well?
They are.
How far in advance?
We've had people at work
As soon as they're
sessions.
scheduled. They're very informal as soon as they're scheduled.
But we need to put some clarity around that, because again, this is think big, right? And that's, that is what we're trying to address
Or
from
perhaps
prior
we
months.
eliminate them altogether. We haven't had one in over a year. They are mentioned, I believe, in
Workshop.
one of the resolutions.
Workshop with St. John's.
But maybe there needs to be a discussion on whether the DRB feels they're still beneficial, and maybe they just move straight to informational presentations only.
In the more formal setting of an actual
Formal
meeting.
setting, which require
Possibly.
notification through this resolution. They're done at full board meetings. Suggestion.
I think the work sessions have been very helpful on some of the larger, more difficult projects where sitting here in this setup, I think ideally we've wanted to have it be a setting where we can sketch, where we can draw, where we can talk about ideas. To me, the applicants that think ahead to that are smart. Whether or not we can actually get a quorum together to get a workshop or a work session is another issue. I think we've given up sometimes because we haven't been able to get a quorum, because they are typically during the day, as part of the business of the applicant.
There's nothing that restricts having multiple information sessions, correct?
Correct.
So some can be a little bit more preliminary than others as you work through
Well,
helping them get to a point where they're more comfortable with putting in a formal application?
and the one thing I'll say about the work sessions, they get a lot of comments, and they're not really officially captured. And I think that there's a possibility that they leave there thinking they're getting comments in one way that maybe they're not.
Guidance that they go act on, and then they're saying, well, but I thought you gave me guidance, and you're like, well, no.
I remember somebody at that work
Yeah,
session
and it really
said
wasn't
this, right?
official
And-
guidance.
Well, that's one of the reasons we've started asking for a quorum, so at least it's informal guidance from a quorum
I
of
think you
members.
wanna stay with the, it's, you're pointing out things that have led us down a path that are causing resolutions to be drawn up. So, I want to go back and double check our resolution statements with regard to work session, as it relates to the
Resolution
DRB.
7 expressly calls for work sessions.
Say that again?
Resolution 7 expressly calls for work sessions. There's a whole section of work sessions.
Right in front of us, right? Okay. And do we talk about,
And I guess my initial comment on that this didn't apply to work sessions was just that I thought that this 21-day, was kind of burdensome towards a work session.
Yeah,
That's where my initial thought and why I asked that question to begin with. So I think we need to look at it, are they're not going to be very helpful if you have to kind of get everything ready 21 days. That's something to consider.
I'm wondering if we want to match language, and the question would be between 7 and 11, do you want to say information session, or do you want to use the phrase work session and we just mirror it in both documents? I think that's a way to solve this.
Yep.
And just pick the phrase that you would prefer.
Well, there's also an informational presentation.
So right
Where's that
now, you've
defined?
got meetings defined of the DRB as full DRB, panel meetings, and work sessions.
Right. and
Maybe
so
that should be a
an informational
pre-application.
Presentation is a presentation that's given at full board. And then there's an application, which is done at full board as well.
Okay.
I think
So
work
it's not
sessions
about
is
the
the right
kind of
term.
meeting, it's about. the
Would you
kind of-
prefer that, it's the right term, but we need to be clear in this document on 11, what we're doing notice requirements for, and what application, what packaging information is made available to the public. So I understand what you currently have. I'm asking you to think a little bit outside of the box, and let's clean up the terminology so that we can match up what our meeting requirements are with what our application requirements are.
So they either information sessions should be defined in resolution 7, or we should change the word in 11 from information sessions to work sessions.
Or vice versa.
Question, is there any of that language in any of the land use resolutions
I'm just looking at that, and there is.
that were recently passed where we may use them interchangeably?
That calls for an informational session, the land use resolution.
Well, if I may, it sounds like there's some more work to be done here.
Yep, absolutely, absolutely.
Sorry about
So
that.
no, that's okay. That is the
That's
intent
fine.
of me, of Julie and I coming back and having the conversation to make sure we get it right.
We'll take it off the board.
Yeah, and that's okay. And we will, she and I will work together to make sure you all get a chance to look at it before your November meeting again, even if we have to delay until September. Point of clarification for staff's sake is we've gotten a chance to road test 11. The immediate thing is, no, you didn't have all your stuff together, even though it doesn't state that. Are you comfortable with staff saying, yeah, you haven't gotten quite all your pieces together, you know, and it isn't going to go until you give us a full application? Is there a comfort level with,
Absolutely.
in the absence of language being put there, at least that staff has now got the ability to say, not quite ready for prime time yet? We'll definitely get it in writing, but I think it would, we don't want you to get a incomplete package in order to make decisions on.
This is, I liked it until a couple of these questions came up and made me think. But when I read this, I said, yeah, it makes total sense.
Okay.
But I think this is good. That's what we wanted, is
Okay.
give us real feedback.
Right.
Yeah.
Let's go get it right.
Thank you for time. We'll
Anything
be
else?
back.
Thank you.
Thank you.
Oh, thank you.
See you next month.
Yes.
Do you want anything to be done with these, or it's good?
We'll work, no, and thank you for your time, and we'll bring more back to you. Appreciate it.
Thank you.
Thanks, guys.
Next on the agenda are the design guideline edits, which we've all seen. And I'm sure there's probably comments covered by every other agenda item. So, Ken, are you ready to
I'm ready.
go?
Yep.
Tell us what you think.
Oh, I don't have any comments. No, I'm ready to go.
Okay.
Yep.
Grace, any comments that you might have?
I'm ready to proceed forward too.
Okay. Richard?
I think we're in good shape. I think our little panel, Neil Barber and I did an exquisite job, and I'd like that noted in the minutes.
Gold star panel?
You want some chocolate?
Graham?
I don't have any issues.
So one comment I had as I was looking at it, and I was thinking about the retaining wall that I have in my house that was approved by the DRB.
I was going to say,
And it is modular block, and it does look like stone, and they're different sizes and shapes, or not. I mean, they're three different sizes, and they're stacked in different sort of random order. But I wouldn't call it, I mean, it sort of has slightly different hues, but it's sort of the same color. And so I think it looks great, and people that see it think, wow, that really is a nice retaining wall. So I think that we just want to be careful not to go too far here and restrict some materials that actually look really nice and create a nice wall. So I want to make sure that we're thinking through that, and in particular, if you scroll.
Are you referring to the variation in color?
Yeah. Yes. Because I think the size is absolutely, but the color itself, because generally retaining walls are going to be of somewhat similar color. You're not going to have a blue, red, yellow block, right? Obviously, that's an extreme comment, but can you scroll down to maybe the pictures, Barbara?
I think that what we were trying to do with these guidelines is to keep in mind they are guidelines, and it allows the panel and or the full board to make decisions based on what they say. So I think we were trying not to be so specific. We stopped all movement or the possibility of making decisions. And if the one you're talking about came in here, and if we thought it was too monochromatic, whatever panel might say it's too monochromatic and not approve it. But I think that was what we were trying to accomplish with the guideline.
So like these walls right here, those are all the ones we're trying to really avoid, right? The ones that are exactly the same. To me, this one, it's slightly different than the others, right? It has different sizes, even though it's the same color. Maybe that's not how you would design a wall, but to me, this one is a little bit different.
I was going to bring that up because I think it would be one that would be disapproved, but I think including that picture could be misleading. So if we took that picture out, I think these 3 examples and the example materials are a great way to
Agreed.
show that to the
I agree
applicant.
with that also.
Sort of looks like my wall, actually.
Violation, violation.
It is his wall.
It's in this man the covenants.
And it's especially the two on the left that have no cap and they're small, and we've seen many, many applications come in front of us that look just like that we don't approve. That's like the epitome.
I think the 3 examples too that we want to keep are the ones you find at Home Depot readily. The one on the bottom right's not easy that someone's going to go pick up on a weekend and just do. So yeah, taking that off might help.
Yeah, I mean, at least the one on the right top has a capstone, which helps it look a little better, but that is still the type of wall.
So the photos in the other guideline?
Oh, yeah.
So you want me to switch out that gray one with one of those other 2?
Yes.
Beige one on the top left would be.
Yeah. Because while the one on the right, we may not like that one per se, that could lead you to disapprove of other walls that look just fine.
Right, and I agree we don't want to do that.
I think that one starts to do what the guideline says, which is it starts to mimic. I mean, you could conceivably have an actual stone wall with that configuration.
Right. Neal, any comments?
I think, again, the point of the guideline is to try to be clear both for us and for the applicant. I think mostly for the applicant, we will certainly get and continue to get all of these from time to time. But I think this guideline now is a lot clearer, and I like getting rid of the picture on the bottom right. I think that one confuses it slightly. If we were to eliminate the number of instances where people come in with clearly what we're trying to avoid, for the 2 on the left there, that would be the intent of what we've been doing, trying to knock down on the instances of those things coming in to the DRB.
I agree. It just cuts down on the confusion on the homeowner's part, and I think that's critical here. So accomplish that well.
I concur.
So I think we're all agreeing that it's well written. Maybe we just get rid of the picture on the lower right.
I'm good with that.
Okay. Any other comments?
So that's across the board for all the landscaping, the various landscaping
I think
ones.
they were all pretty
I'll
much.
change
And
it
then
too.
there was the signs. Signs on
Do we need a
Motion?
motion? I think we need a motion.
Okay, I'll make a motion that we approve the revised guideline as presented with the one change of removing that one photograph we've been discussing.
I'll second.
Now, this is including the sign guideline as well, which is part of the package you all are looking at tonight?
We're just talking about that right now. I don't want to confuse the issue.
all the landscaping.
All the landscaping ones.
So we're voting on the landscape wall issue and not the signage, is that right?
Right.
Yes.
Someone that was on the sign committee should probably make the motion for their.
Any other comments on this section?
Celebrate.
All in favor?
Aye.
Opposed?
Great.
You're opposed?
No, I said aye.
Oh, okay. Okay.
Celebrate.
Late eye.
I was trying to help my colleague here with the password for Wi-Fi. I apologize.
Lost connection, I'm sorry.
That's the box.
Celebrate.
50 years.
Thank you,
With the exclamation point at the
Thank
end,
you.
and the C is capital.
thank you.
Okay, what's next? The signage? Anybody on that Gold Star panel that would like to talk?
Who was it? Who was the panelist?
It was Grace, Nick, and I, and we've traded this around, and we felt like we've maybe addressed some things that haven't been clear in the past about what's reviewable and what doesn't require an application, and I'm just reading through it. Staff has very nicely formatted this, which helps it all read a lot more clearly than in our draft. So to make it clear, certain signs like on doors, addresses, things like that, don't have to be reviewed if they're limited in size and area. And it's a fairly small area, but you don't have to come in for that, which we thought made a lot of sense. If it's a temporary sign And I think that that was giving someone a little more leeway in size because of the fact that it's temporary, it's promotional, presumably, not installed for more than 30 consecutive days or a cumulative total of more than 60 days during a 12-month period, that you can go up to 25% of the glass area, and you don't need to come in for an application for that. So I think merchants, you know, we're trying to be very considerate of retail and of merchants that want to do advertising, so giving them 25% of their window area. And then when you flip back to the edits then for things that require an application, you know, those are the permanent things. And we're being fairly restrictive there to how much glass you cover on a permanent basis. And that's consistent with what we had seen in some other jurisdictional guidelines where you're trying to preserve an attractive retail environment and avoid the wallpapered over storefronts that we occasionally deal with. Of course, again, these are guidelines and people can continue to come in and apply for things, but at least we have a bit more guidance now, I think. So that's kind of a summary.
Given the fact that websites come up so often, I didn't see it in here, but would we be able to add something that says we discourage the use of websites?
I mean, I think this is still covered, just as anything that one puts in a window, period, is covered. We don't specifically talk about telephone numbers, addresses, anything. It's how much glass you're covering. If you're within the guideline, it can be, to some extent, whatever you want to present. But I don't know that we specifically talked about websites any more than we did telephone numbers or other things.
I'm just looking at, because there are these are also in there, the tenant signs.
We didn't get into tenant signs. We were only looking at retail window signage. Glass window signage.
I thought you guys did a good job.
Appreciate that.
Thank you.
So I'm trying to understand just the last section that says signs for windows and door signs that do not meet the criteria for no application. So this is the catch-all kind of, it's page 6 of 9 in what I'm looking at.
So this is the general guidelines for window signage, window and door signage.
If you're
So
bigger than
10%?
Yes.
Okay.
You still have to have it approved because it's permanent. And we're trying to limit it to
Okay, this is permanent. Okay,
a very small area,
right.
relatively small area.
Okay.
I mean, again, it's a guideline.
Okay. And did you say something about neon signs in here not being, where's that? I read it at some point, but now I've lost it.
Illumination.
You'd think it would be there, but I don't see it.
Oh, no, it must be in the without application.
Yeah.
Okay.
It says including neon signs are not allowed.
Illumination is there under commercial public.
Yeah, but I don't see neon.
Not allowed.
Oh, yeah, internally illuminated
last
windows
line.
and door signs, including neon signs, are not allowed. I was just trying to think of, like the UPS store in South Lakes. They have, I don't know if their signs they have hanging in their window are neon, but they're.
Well, I had two questions that I had thought of that I wanted to bring up for discussion, if it's appropriate at this time. One is that you all have approved some neon signs on occasion. So I don't know if you want to state that they are not allowed, because they have been approved.
Okay.
The neon, the open signs and some neon signs. And then the other question I had is for the ones that are allowed without application, it was a sign that takes up no more than 25% of a window. If you're looking at a storefront, does that mean one sign per window pane that doesn't take up more than 25% of that pane?
I think it's kind of, I asked the same question as I was drafting that, and I think you can interpret it either way. I don't know that it makes a whole lot of difference in the end.
Of course, they'll interpret it as loosely as they can, and they'll put one up in each pane. And if no more than 25%, two muted colors small size. If you all are okay with it, then that's fine. I just wanted,
Doesn't it
because if
still
that's not,
work the same though? If it's 25% of each individual glass, it's 25% of the whole when you add it all up.
yes,
So it's still okay.
yeah. I just wanted to make sure because I didn't want somebody to go out and put 1, 2, 3, 4, 5, following those guidelines, and then,
Now, this is just no application,
And it's
right?
temporary.
yeah.
And
It's temporary, and it says one sign. No more than one sign is visible.
Per window.
Per window.
Sign is not a window or door sign is defined below, is less than 1 square foot. Oh, that's just whatever. No application required.
Right.
No more than one sign is visible. So if you
Right.
just want to put.
We thought about putting you on our committee, by the way.
That's
I
like
guess
for-
this meeting would have been shorter if I had been on it.
That's like for a yard sign, too.
Okay.
That's how we operate.
Okay, I mean, it does look good. I just had those couple
No, I think
questions.
it's all very much subjective.
Mhm.
I like so much of this, I think, we see how it goes over the next year or two. We don't have these coming in front of us forever that often.
True.
So if something's not right, we tweak it.
Pardon the noise.
Under these guidelines as written, would that karate sign be okay for?
No,
It would not.
no, it would have been too big, too many
Too big,
colors.
too opaque, oh, too many colors. Okay. That gives me a point of reference, thank you. But he could redesign something within this and.
That's the one in South Lakes you're talking about?
A lot of the sign guidelines, when you look online at what other jurisdictions are doing, a lot of them are dealing with pedestrian areas and urban environments. It's just like so much of what we talk about. Design guidelines don't seem typically to be about suburban retail centers. So that's where I think some tweaking might happen over time. Maybe it's different in our village centers than it would be in a streetscape where there are a lot of windows together. I mean, we've got cars and a lot of stuff happening visually anyway. Maybe some of this isn't this important. But for now, I think, this is a starting place.
Ken, any comments?
Like I said, thought they did a great job.
Grace?
I'm fine.
No additional comments? Okay, I'm good.
We skip you?
I'm good.
No,
You, okay.
silent, yeah, it's visual.
Good. I guess the only question I have is, would it be worth trying to add some language to say no website logos on signage? I mean, we keep having to turn people down because of that, but I don't think it's
Yeah, I
clear.
think if we generally, where is it covered now? What language in here would you look to back us up when we try to eliminate extraneous? I think there is general language in here now. I'm not pointing to it as I talk, but
Yeah.
there's always been general language about keeping signs visually quiet.
I think it's under the commercial tenant signs, is that right, Barbara?
Yeah, monument
No, it's
signs.
not, but it's not considered, when you all are saying no website, you're not talking about a tenant sign, you're talking about a monument sign.
Monument sign, yeah. Is that in here?
Yes.
Straightforward, unornamented, with minimal pictorial graphics. So
Design compatibility kind of gives us the,
I think we have the latitude to make the votes that we have, but we keep telling them no phone numbers, no websites. So can't we just say that?
so they're discouraged.
But you don't always. This is again,
Mm-hmm.
just the same with the neon signs. I think you need to be careful. If you're gonna say something is not allowed, then you need to not allow it consistently.
Agree. That's the problem we're having right now.
You have
We're
on
not consistent.
occasion allowed some phone numbers, some websites.
it's very rare.
I agree.
I can't think of any myself.
So maybe they would be discouraged rather than not allowed.
Strongly discouraged.
I guess
I agree
I would
with
put it under graphic design, monument signs under that graphic design, the very first one, where it said the sign should be straightforward and unornamented with minimal pictorial graphics. Website listings or whatever are discouraged.
Phone numbers.
Text limited.
Generally not
Text-
approvable.
Text should be limited to general identification of the property in parentheses, not include telephone numbers, website addresses, etc.
Yeah, not on monument signs.
Yes.
Any Other comments about that? Is that okay? Any other comments before we get a motion? May I have a motion?
Make a motion to approve the guideline edits to the signs guidelines as presented with the addition under monument signs that we just talked about.
I'll second.
As amended.
As amended.
I'll second. All in favor?
Aye.
Aye.
Opposed?
Don't do that to me again.
Good. Okay, were there any other design guideline edits?
Now's the time.
Well, I had sent out an email to see if anyone would be interested in looking at the privacy screen guidelines. I think they could be updated. They haven't been looked at since 2009. So I was wondering, I would be willing to chair a committee if anyone else would be willing to serve on it. Grace?
I could come and pencil you out.
Neal, give me a break.
Maybe I should stay off of it then.
Are these privacy screens or not party walls or anything of that
No.
nature?
Just the privacy screens, the lattice privacy screens.
Okay.
Yeah.
Properties.
Most privacy screens in Reston are covered by the cluster standards. But I understand what you're saying, if we need to update that.
They're not.
We've had a lot of disputes lately on that too, so it probably is worth investigating.
Well,
I think it's a good idea, I don't know.
help us understand that. In your particular concerns, it was something that was in the cluster standard or in the design guidelines? You don't have anything in your cluster standard?
No, and
Sure.
several of them I've noticed lately, they're not in the cluster standards. Some get approved, some don't. I mean, I think it bears looking at it. I mean, I've seen different pictures, and people talking about putting it in their cluster standards.
Even in the single family, we had major discussions about two cases recently.
Right.
One that, I don't know if it ever went to legal dispute, but it was close if it wasn't. And the one with the folks that looked right out at where the hill and the fence in our panel, I guess, is when we reviewed that. And while there was good language, it maybe could have been tweaked a little bit to make it a little...
Well, I guess one thing, when I read it, and it says you can only have it, 3.5 feet high, and most, trellis, I'm not,
I can't hear you.
the term is escaping me. It's a 4 by 8 sheet, 4 by 8 feet sheet. Lattice, thank you. So why do we cut a half, 6 inches off it? I mean, I don't know.
I don't think we need to try the case tonight, but I think it's fine to look at the guidelines. That's what we're trying to figure out.
Right, and so, I mean, it's just things that come to mind when I look at it.
And back to the clusters though, I mean, the clusters need standards. To me, it's most difficult when a one-up person that's in a cluster in a townhouse or a condo or whatever wants to do something and his or her cluster doesn't have a standard. And we usually try to send them back and create a standard. I don't understand why any cluster that has decks, if they're allowing privacy screens, would not then have a standard for what they should look like. Otherwise, you're kind of defeating design review in general because you'll end up with a hodgepodge of a bunch of different things. So, to me, that's a procedural thing, maybe for clusters to be identified that don't have standards for these things. It doesn't happen a lot, because usually the cluster does have a standard.
So we have a chair for this new committee. Who else wants to be on it?
I'd be happy to be on it.
Okay, thank you.
Anybody
Richard?
else?
I think we need a professional member.
Oh,
Too late, people? Oh, no.
Very experienced. Richard?
Sure,
Grace?
sure, I'll do it, sure.
Thank you.
All right.
Is that enough? 3?
It's
As long as it
whatever
doesn't
you want.
violate any of the standards I've already abided by.
There you go.
You're grandfathered regardless.
That's right.
All right, any other design guideline edits? that
Well,
we need to
okay,
talk
so
about?
if you all are going to form a subcommittee and work on privacy screens, then that would mean that we're going to continue to hold off on your presentation to the BOC on the edits in general, correct?
Sounds like it.
Okay.
Unless we want to proceed with the ones that we probably only want to do it once, right?
Yes.
Trust me, you do.
Yeah.
I'm just reading body language here.
Yeah. I was
goes
gonna-
back
Facial
that way.
expressions?
I felt that.
I almost fell out of my chair.
I didn't even see her and I felt that.
Okay, well, let's hold off then. Okay, any other design guideline edits?
Well, just on that question, not to lengthen this, but we could stop here with our guidelines and then over the next 12 months do this so that then next year that guideline's done and not stop all the good work we've done already. And we don't have to stop everything to do this.
That's a good point.
So if we want to just stop where we are now, and one of the many things we'll look at over the next year happens to be privacy screens, and something else may come up in the meantime. But, I mean, why wait another 2 or 3 months to get this other stuff out? Just a thought.
Where would we stand now? Would this have to be postponed?
All of the guidelines, that even though you all approved them, you did ask for edits. So what I would typically do, I would make those edits, I would send those out again and make sure everyone's on board with them. Once there's agreement that no further edits are necessary, then what happens is we officially request the BOC to place John on the agenda, and he goes to the BOC and he presents the edits as they exist to the BOC. The BOC provides comments, which he then brings back to the next full board meeting to provide you all with a report on what the BOC thought. Once that is done, then he goes back to the BOC again to report back what DRB's comments were to their comments. And that one has to be advertised. Then it goes to the RA Board of Directors. That one has to be advertised in the newspaper for 2 weeks. Then the RA Board would approve them, and then they become final. So it takes
It's quite the process.
several.
So if we want these in,
I would say John should move forward.
But we don't know yet that he can even be added on the November.
That's fine.
Calendar, it may not even be December. I mean, November right now might even be slated for a special
Well, I
hearing
think by
because
the
of
time I
assessment.
get these edits done and back out, it'll be too late for the November BOC, to be honest. I mean, that's only 3 weeks away, or 2 weeks away.
what's that?
The November BOC.
I don't think the November BOC is even an option. I
Okay.
think there's assessment stuff going on, so.
All right, so I would
Be looking at
suggest that
December.
we move forward on the edits that we talked about tonight.
I'd like to get the retaining wall stuff in. Those are the ones that are
Yes.
the most
Right.
difficult once
They
they're
come up a lot.
installed.
They do.
That's just my opinion.
And I know we're trying to deal with the commercial projects also, sort of long-term, that's gonna take a while, so maybe the fence stuff can be rolled into that in the future.
Unless you guys could do it in 30 days. So-
You
That's
never
just,
know.
I'm saying is, so we're looking at possibly December?
Yeah.
When, John?
Right, December BOC. So if the privacy screen subcommittee could get the edits done, get them to me for me to do them, so I could send them out before the November full board. If you all could approve them at the November full board, we may make the cut for the December BOC, and he could present all of them.
Pressure.
You've got.
I mean,
Yeah.
if
Be
it's
busy
if it's
and-
possible, that's fine. If it's not possible, it's not the end of the
It's
world.
not a baby. It's not like you're gonna have
I think that's a
anything to do.
tough time of year to
Yeah.
try to get things like that done, given schedules and everything that's
Yeah.
going on.
Yeah.
The holiday season.
Earth shaking.
Y'all can give it a try and see what happens.
Yeah, we'll try,
Yeah.
but.
So we can have our committee proceed, and then we'll just, once we get those done,
Absolutely.
we'll roll that into next year's sort of round. If that's okay. Is that okay? Anybody
Almost
opposed?
they're like lightning, and they get it all done, and we can roll it all together.
Okay. Anything else on that? Tracy? All right, DRB calendar.
I sent out the proposed 2017 DRB calendar. Is everyone okay with it?
Works for me.
You're asking the wrong.
A year
person.
from now, Ken?
Yeah,
A year
really.
from now?
Give me a break.
I lost-
October-
It looks great to me.
Yeah.
October seemed to be a bit of a problem.
I've been counting, and you tend to revise the calendar about 6 times a year, so I
Oh,
think
I
it's,
do not.
I think it's okay.
Okay.
4 times.
At the panel recomposition, right? You
That's
have
the
to,
next thing on the agenda.
well, you always, when that happens, you
Yeah.
do it then, right?
People come on and off
Mid-year or
panels
Spring or.
in March, and it has to get revised at that point, too.
When there are meetings and which panel's meeting on which week. There was one change this year, which was unusual.
All right, we have, at the end of March, Neal, Barbara, and myself, terms expire.
Cross your fingers.
Never know.
You all would approve the calendar?
Need to get a life between now and then.
Does it need a motion?
Do you need a motion?
I move to approve the proposed 2017 DRB calendar.
I'll second it.
All in favor?
Aye.
Schedule's for
Approved. Thank you.
Yeah.
All right, panel compositions.
Okay, so because the resolution is not in place yet, we need to continue with the formalization of the composition for the panel. So at this point, for the next week's meeting, October the 25th, Ken is intending to replace Linda on the panel. On the 11/1 meeting, we have Linda set, we would like to have Linda set up as a backup for Barbara, who may be busy.
Birthing a
You know she's going to be busy.
Yeah,
Holding a baby.
I'm not going to be here
Holding a baby.
on the 1st.
And then 12/13, which I know we have a November meeting between them, but I figured we would just go ahead and do this. Linda would replace Ken on the 12/13 meeting. So that's Ken for Linda on 10/25, Linda for Barbara on 11/1 if necessary, and Linda for Ken on 12/13.
Can
Sorry,
do.
12/13,
See what
it's
the
just a
layperson-
panel meeting, right?
12/13 is just a panel meeting. There is no full
Right, right.
board meeting.
Okay.
It just-
Who's on your panel?
John Graham.
Okay.
Well, I would make a motion to approve those substitutions, is that how we do it? I forget.
Second. All in favor?
Aye.
Approved. Any other topics?
I'd make a motion to adjourn.
Second.
All in favor?
Aye.